Great, we'll start now, just because there's lots to get through. Firstly, just want to say thank you for coming to this webinar and just to see so many people join as well. I'm glad, despite obviously with virtual working, kind of people being back in offices, virtual events are still happening, and it's just, yeah, it's great to see so many of you here. I'm Saranya, and I'm the Whole Housing Approach Programme Manager, and I lead the Whole Housing Approach Programme, and part of that is the private rented sector. So that's one of the elements which we'll go through in more detail. So for today's event, we're going to launch some new guidance today to help domestic abuse practitioners support survivors who live in the private rented sector. And we're really lucky today because we've got some great guest speakers, including some domestic abuse practitioners who'll present some case studies. And also we've got a housing barrister who helped us develop this guidance as well. And at the end of this session, we'll hopefully have some time for questions. So if you do have questions, please do hold off asking them until the end, and make sure that you put them in the Q&A section and not in the chat as well. This webinar is being recorded, and we will publish this with the guidance as well. I'm now going to hand over to my colleague Clementine, who's the PRS lead for Stand Together, and she's going to give a quick introduction of the whole housing approach and our PRS project as well. So over to you, Clementine.
Thanks, Saranya. Let me see if I can just share my slide. So I'm the PRS lead at Standing Together, and just to give you a bit of context of the PRS project, it fits within the whole housing approach team. And the whole housing approach is basically a framework to help local authorities respond to the housing needs of people experiencing domestic abuse locally. So the PRS project is up here. It's one of the housing tenure types that survivors might find themselves in. And basically, we're looking at a range of interventions or options that local authorities should implement to respond to the housing needs of survivors. Some interventions are better suited than others, depending on the housing tenure types. And today we're going to look at the interventions that are best suited for people living in the PRS. So at the end of the webinar, I'll come back and speak a little bit more about the sanctuary schemes, for example, of flexible funding. And so the PRS project really aims to improve the housing outcomes for survivors living in private rented accommodation. It's quite important because most projects in domestic abuse usually focus on social housing, but we know that a lot of people live in the PRS. In England, it's 19% of people, so 1 in 5 people live in private rented accommodation, and that's increasing. And we know that a lot of survivors of domestic abuse, when they leave their property, will be made an offer of private rented accommodation. So it's very important for practitioners, domestic abuse support workers, to understand the PRS and how to help the clients who live in the PRS. There was a study a few years back that found, so a large-scale study of the housing situation of domestic abuse survivors, that found that 30% of them live in the PRS. So that's why it's very important to focus on that tenure type in particular. So as part of this project, a lot of my work is to influence national and local policy and legislation. I'm working with a lot of PRS professionals to develop kind of good practice and share best practice across the sector. I'm developing training and guidance and resources. So this guidance that we're launching today for domestic abuse practitioners is one of those resources. We're also developing guidance for PRS professionals to understand domestic abuse better. And we're also trying to gather experiences of survivors living in the PRS so that we develop kind of a good evidence base to help our influencing work. And we're supporting some local areas locally to improve their response to domestic abuse for every survivors, regardless of their tenure type. So that's the introduction of the PRS project. I'll hand back to you, Saranya, for the next speakers.
Great, thanks for that, Clementine. So we're going to hear from some frontline practitioners now, and we really want to highlight the experiences of women who are experiencing the private rented sector and also experiencing domestic abuse. So we wanted to ensure that we get frontline voices within this event. We're now going to hear from Franky, who's going to talk about a particular experience, particular case study that she worked on, and Franky is an IDVA at Advanced. So over to you, Franky.
Hello everyone, good morning. Can you hear me okay?
I'm just going to say, Frankie, it's just a bit quiet. I don't know if you're able to speak louder, that would be great, or if you've got a headset, that would be fab.
Is that okay now?
Yep, that's perfect. Thank you.
Thank you. Hello everyone. Yeah, I have a case study of a young woman I worked with as a housing advisor. She's a young Canadian woman that has lived in the UK for a couple of years, and she was renting privately by herself. And at a point, her boyfriend moved in with her. Of course, she was initially a sole tenant, but when it was due for the tenancy to be renewed, they made it joint tenant. He became a joint tenant, and they were living together. The abuse started, and of course, she was enduring it, kind of, and minimizing and ignoring it. Both of them are professionals and earning quite well. She is a barrister. He is a regional manager of an organization. The abuse kind of intensified during pandemic. So there was a lot of coercive control, a lot of monitoring her movements. He installed tracker on her car and on her phone. There was also sexual abuse that is going on, including rape. Physical abuse kind of became like a regular thing, and verbal abuse. Because of all this, she has this huge sense of shame on her. And she was enduring the abuse and continuing to live with this guy because of her immigration status. The boyfriend is an European citizen, and she is Canadian, and one was hoping to depend on him to apply for her right to continue to live in the UK afterwards. So because of that, she was enduring the abuse, and of course, this resulted to a lot of psychological issues. So the referral came to us through her GP. Of course, she goes to her GP to discuss about her depression and anxiety as a result of all that is going on in her life. So she was referred to us, and after assessment, she was referred to Marak, and she was given all the options that are available to her, all the legal remedies to be able to address these issues. But she was very hesitant. Even at the beginning, she was very reluctant to engage with me, but we managed to build a trusting working relationship. And of course, she disclosed all the issues of not wanting to, the whole rape that she experiences. And one of the Mondays, I came into work and she called me and talked about experiencing rape the weekend before. And I pleaded with her, said, this is your opportunity to speak to the police about this. This is your opportunity to deal with this. If not, it's going to continue to happen and affect your mental health. So I encouraged her. That was all I could do. Of course, I cannot force her, and I left it with her. So she went away. The next day, she called me and said she followed the advice. So she spoke to the police. And of course, I kind of helped her to understand that police has been trained with regards to domestic abuse, and they would deal with things sensitively. They would try to meet her where it feels convenient for her to speak about issues that are happening. And that happened. She reported to the police. They took statements, and the perpetrator was arrested and was given a domestic violence protection notice. So this kind of helped her to have her space and have her time and to reflect and think of the next move. So with regards to her housing here, the joint tenancy is still going on. I suggested the idea of finding another private rented accommodation, and she was quite hesitant about that because, one, of course, the cost of it, the cost of raising another deposit, that she would not be able to do that because of situation, and even finding the property because of pandemic as well. So she kind of turned that offer down. I suggested the option of a sanctuary scheme to ensure safety around her home and change the locks. And she said, Franky, I've already done that, and I feel the home is secured now, and I'm happy to continue to stay here. So that was where we kind of came to the end of her case. And the last thing I did with her was to refer her to an immigration solicitor who supported her onwards to regularize her stay. Yeah, thank you very much. And if you have any questions, feel free to ask at the end of the seminar. Thank you.
Great, thank you, Franky. That was lots of detail there, which was really helpful, and to understand the context as well. So thank you for that. We're now going to move on to Forus from Hopscotch, and Hopscotch are a organisation, and they essentially support women of colour. And obviously, as many of us will know, women of colour experience additional barriers when experiencing domestic abuse, and also the housing sector as well. So Forus is going to talk us through another case study that she worked on while she's at Hopscotch. So over to you, Forus.
Hi everyone, good morning. I'm just going to talk about one of the cases that we dealt with. So we specialize in working with Black and minoritized women, and as we know that, in addition to all of the existing barriers, Black and minoritized women face additional barrier because of their intersectionality. Now, it was last year we were supporting this young single South Asian woman who was around 20 to 23 years old. She was living in kind of an unhappy marriage where there was like a lot of psychological abuse, there was coercive control, and she had she used to work in retail, and she had to leave her job because her husband and in-laws did not really like her going out to work. And she kind of, went into depression, and she couldn't handle it anymore. And that's when she kind of got in touch with us, and we supported her. Now, at that moment, we could feel that there was like some form of physical abuse, not a lot, but she wouldn't tell us that, it was physical abuse. She would say that she had an accident or, something like that. Because it's quite difficult, it was quite difficult for her to kind of show her vulnerabilities in a way, because she didn't really have language barriers. So we supported her, and we provided her with all of the advice, and she decided to move in with a relative because she wasn't really prepared to go through the divorce route. She needed some time to think, and her family weren't really particularly supportive. So she went and moved in with a relative, and we supported her, and she applied for social housing as well. She didn't really want to go into a refuge. But yeah, she applied to the council for social housing, but this is where the kind of challenges started, because her application for housing was declined because of her age, and also because of the eligibility criteria. Because in private rented sector, they look at whether the person is employed or not sometimes. So because she was unable to provide any kind of employment guarantee, she was rejected from that, which was even more kind of difficult for her to handle, because she's always kind of worked, and she had to leave work because of, you know, the coercive control and the abusive relationship that she was in. And there she was kind of homeless, looking for a place to go to. She was even willing to move into private rented, but, you know, she wasn't unable to access it because of her lack of employment. She was kind of looking for jobs, and we supported her to provide all the documentation as form of evidence that she was attending interviews, but she wasn't able to kind of get the job at that moment, but none of those were considered. The other barrier that she kind of faced was, in terms of the financial side of things. So she was getting universal credit, and she was getting a single person's rate, which obviously did not include housing benefit. So that was another issue. You know, she was not really able to also afford the 2 weeks rent deposit, because she didn't have much savings, and she wasn't employed, and her family weren't really supporting her at all. So she didn't have that deposit to move into private rented as well. So it was like she was stuck in a vicious circle. Yeah, so the deposit that they asked for was around £400, you know, that she need to pay, and, you know, she just couldn't afford to pay it. So yeah, these were the barriers, essentially, the high amount of rent deposit, the fact that she had to show employment security, and the fact that housing benefit was not covering, would not cover her rent. She didn't have any choice at that moment, because there was no way that she could go back and live with her husband, because at that moment in time she had made the decision to go through divorce, and her family wasn't really supporting her. And she couldn't also live with her friends. So it was a very difficult time for her. Now, I just want to kind of talk about other barriers that women face from the Black and minoritized communities. Apart from language barriers, there's also a barrier on their side, or, in general, and that is around an awareness of rights as tenants. Because when we support women, sometimes they don't have that support system. They don't have a support network like families or friends, and sometimes they're kind of ostracized by their families because they took the decision to move on. And also, they have trauma because of the abuse that they have been through. They start developing symptoms of trauma, in addition to the existing barriers that they have. And these kind of make it very difficult for them to be confident and to talk confidently and to challenge the landlords. So, for example, we have supported women who were living in really damp conditions in private rented accommodations, and where there were other kind of disrepair issues as well. And because of, apart from language barriers, because of perhaps the trauma and perhaps the lack of support network, they did not have that confidence to kind of complain about these issues to the landlord. And even at times when they did complain, their complaints were not taken seriously. In fact, they were kind of told by the landlords that they're not paying high enough, and that they're going to be asked to leave soon, and the landlords are going to get a new tenant over. So these are the kind of techniques that are used in a lot of cases. And sometimes we get to know them when we're working with them and when we're supporting them. But unfortunately, at times, there are times when obviously they don't get any support, when they don't, go to professionals and speak about these issues. So I think that one of the main barriers is the fact that, some women are really unaware of their rights as tenants. And the landlords are kind of taking advantage of their situation, of their vulnerabilities. And it is really sad because, because sometimes their housing benefit does not cover their entire rent. And the women, they have to kind of budget by compromising on other necessities, sometimes by compromising on things that are needed by their children in order to kind of make sure that they have a place to live in. But the amount of money that they're paying to these landlords isn't really worth it, because at the end of the day, the rent is going up, but the condition of the house keeps on deteriorating. So yes, so these are the main kind of challenges and barriers that women from minoritized communities face when they flee DV and they kind of start living in private rented accommodations. Yes, we're just continuing to support them as much as possible. Thank you.
Great, thank you for that. And that was really insightful. I think especially when you're talking about the fact that one of the biggest barriers is that women are unaware of their rights as tenants. And I think that's a big note for the professionals here, kind of highlighting what are their rights, and also to limit kind of exploitation from landlords, because obviously not saying all landlords are bad, but we do see a lot of terrible practice, and actually reminding women. And also, Forus, I really liked that you touched upon the fact that a lot of women, they don't have many options, but as professionals you can provide them with options and information, which just shows how vital your role is. So thank you for that. We're now going to hear from Angharad Monk, who's a housing barrister, and Angharad worked with us on this guidance and really supported and helped us to develop this. So she's going to present an overview of the rights of the tenants in the PRS to highlight the key information that practitioners should be aware of when supporting survivors who are in the PRS. So over to you, Angharad.
Thank you, Saranya. Yes, I'm going to have a chat to you. It's going to be a little bit of a whistle-stop tour, I'm afraid, because the guide itself is extremely comprehensive, and it covers such a large amount of material. It's just not possible for me to go into all of it in a sort of quick discussion now. But what we're hoping this guide is going to provide you with is a really helpful tool to identify what options there are available to survivors in the private rented sector. And as everyone else has already said today, this is a vital part of giving holistic support to survivors with their housing issues, because in reality, sometimes social housing or even a homelessness application is not either available or the appropriate option. But what I'm going to focus on just for the discussion today is the different kinds of occupation rights that survivors can have in the private rented sector and what that means for them in practice. Because if we can focus on that, what we're hoping is that once you've identified the occupation rights that your client has, then you should be able to use the guide in order to find out the relevant information, as Clementine's going to explain in terms of how to use the guide. So just a quick warning, housing law can be a bit complicated, and it's important to look at the detail, and unfortunately there are situations in which it may not be possible for the survivors that you're representing and assisting to actually get professional assistance from a housing solicitor. So you have to sort of try your best to work out what their rights are. If you've got a situation where you're struggling to work it out and it seems a little bit more complicated, what we'd recommend is if you can't find the answer in the guide, then use the resources that we've highlighted, particularly on Shelter's website, because Shelter's really good at helping you to identify exactly what kind of rights people have in a kind of common sense, non-legalistic way. The first thing I'm going to talk to you about is assured short-hold tenancies. So this is going to be the majority of people that are living in the private rented sector. They'll be living in a house that's held under an assured short-hold tenancy. There will often be a written tenancy agreement, but it's important to know that there doesn't have to be one. Sometimes things are agreed just between people by word of mouth, and that still will be a tenancy agreement if the relevant conditions are met. So you can also get a situation where some people will have an agreement that calls itself something other than a tenancy agreement, but it still will actually be a tenancy agreement in law. And the reason for that is that when the courts are deciding what is or isn't a tenancy, they don't look at so much the words of an agreement, but they look at the actual reality of the situation. And there's 3 features that make a tenancy. And the first one is that the person that's living in the property has something called exclusive possession. So I'm going to talk to you a little bit about what that means in a moment, but it's got a very specific meaning. The second 2 elements are that you've got it for a period of time, and then that you're paying rent. So really the main issue most of the time that you're going to be looking at is whether they have what's called exclusive possession. Now, it's not entirely straightforward, but essentially what it means is you've got a legal right to stop other people from coming into the property, so to exclude others, and that includes your landlord. But it doesn't mean you necessarily have to have the whole of the property, and you sometimes have situations where if people are living in a sort of room in a house in multiple occupation, which is more and more common these days, they could have a tenancy of just that room. Most of the time, if you've got a survivor that lives with their family in a self-contained accommodation that they're paying rent for, that is going to be a tenancy most of the time, unless there's a major oddity in the sort of arrangement there. But what you should note is it doesn't necessarily mean that the survivor herself is a tenant. So we'll talk to you a little bit more about what different arrangements there can be. So assured short-hold tenancies, the other thing to know about them is there's essentially 2 kinds. One is called fixed term, and the other is periodic. And periodic means that instead of it having a sort of 6-month or a year, it rolls, and it will roll either usually on a weekly or a monthly basis. A lot of the time, people are given a fixed period tenancy, as you'll be aware, any of you that have any experience of the private rented sector, often for 6 months or maybe a year. But sometimes, particularly when people don't have a written tenancy agreement, sometimes the tenancy will just have been rolling from the beginning, and the agreement was always just that they would pay rent every month. It is important to try and work out which one you're dealing with, because that can be relevant to some of the rights and liabilities, and the guide hopefully will identify when that's relevant when you're going through it and looking at the particular section that you need advice on. Another really important thing to know is that when you've got a fixed term tenancy, when it ends, that doesn't mean that your client no longer has a tenancy. What happens is that the law says that basically a new tenancy starts immediately after the fixed term ends, so long as the person is still living there. And that tenancy will be a rolling periodic tenancy on the same terms as the one that you've just had. So if it was a monthly tenancy with a certain rent, that term will still be the same, but they're now on a rolling basis rather than on a fixed term. So the main other kind of situation that you might get, other than assured short-hold tenants, is lodgers. Now, the easiest way to spot when somebody's a lodger rather than a tenant is just that, are they living with their landlord? And most of the time, if they are living in a property where they share, they have a bedroom and they're sharing communal facilities with their landlord, a lot of the time they will be lodgers. It's not always the case, but most of the time that will be right. And it's important to know that, because lodgers have significantly less rights in terms of their security than tenants do. Lodgers can be excluded by the landlord very easily. You don't have to get a court order or a warrant of eviction in order to evict them. So as I said, there can be more complicated situations, but if something unusual comes up, I would use shelter as the first port of call to try and work out what someone's status is. So then the next important thing is if you've worked out that there's a tenancy, it's an assured shorthold tenancy, it's then really important for you to work out who is the tenant or tenants, because it doesn't necessarily mean that the survivor herself is a tenant, just the fact that you've established that there's a tenancy agreement. If you've got a written agreement, it should be quite easy to work this out, because it will list the named tenants in it. But be careful of when a tenancy agreement says that you've got permitted occupiers as a separate category, because that doesn't mean that they're a tenant. They actually have to be named as a tenant in the tenancy agreement. Obviously, things are a little bit more difficult if you haven't got a written agreement. And again, because that's a bit of a more complicated situation, I'd recommend trying to talk to shelter or over the helpline or something to try and work out who in fact is the tenant in that situation. It will depend on how the contract was negotiated, and it probably depends a little bit on who pays rent to the landlord as well. But it's something that you'd have to look at all of the circumstances. So essentially, if you've got a tenancy, the survivor you're helping could be in broadly one of three situations. So she could be the sole tenant. So that means she's the only tenant, and whoever she's living with, if she's living with the perpetrator, he is not a tenant. She could have a joint tenancy, and that possibly would be with the perpetrator. That's a situation that will obviously come up quite a lot. Or she may not be a named tenant at all, and perhaps the perpetrator himself will be the sole tenant of the property. It's really, really important to try and work out, if you can, which one of those situations you're in, because everything really depends from there on, in terms of what you're trying to achieve. How you go about that is going to depend on exactly what that situation is. So there are other rights to occupy a property other than being a tenant. So if your client is not a tenant, but she is actually married to or in a civil partnership with the tenant, and obviously that may be the perpetrator, she has something that's called matrimonial home rights, which means that she has a right to carry on living in the property. It's worth bearing in mind that that works two ways. So if she's the sole tenant and she's married to the perpetrator, then he's also going to have matrimonial home rights to occupy the property. That doesn't apply. First of all, that doesn't mean that it's not the same thing as being a tenant. So it doesn't make you liable for rent or anything like that automatically. It just means you have a right to live there. Also, if the person is not married or in a civil partnership, then it doesn't apply. So people that are just cohabiting with a tenant, essentially what's happening there is you're just living there with the permission of the tenant, rather than having a strict right in law to live there. So it's important to sort of work out exactly what the status is of the relationship. Are they married? Is there a civil partnership? Do we have some issues with matrimonial home rights? So in terms of what all of this means then, as I said, it's not possible for me to go through every single different issue that's in the guide, and we're hoping that it's going to be quite helpfully set out for you to be able to pick up on the issues that are important to your individual client. But the two key things are that, in my view, that survivors may be keen to know is, first of all, if she wants to leave the property, how is she able to do that without being liable for the rent or possibly any other damage at the property? And then on the other hand, if she wants to stay in the property, how can she exclude the perpetrator and make the property safe for herself? And again, the answers to those questions depend very much on what her status is there and what his status is there as well. So you need to take both of those things into account. With leaving the property, if she's not a named tenant, then leaving is very simple, and she can essentially just leave and she won't be liable for any of the rent or damage to the property. If she's a tenant, either the sole tenant or the joint tenant, then she'll be liable technically for the rent and damage until that tenancy ends, and it can only be ended by giving notice and also giving up occupation, which could be an issue if she leaves the property and the perpetrator remains. So that's a difficult issue. If she's still in the fixed term, then actually the tenancy can't be ended without the landlord's permission anyway. So that might be something that you can support a survivor with in terms of negotiating with a landlord to essentially sort of give up the property by consent. After the fixed term, she can simply give notice, and basically if there's more than one tenant, any one tenant giving notice is enough to end the tenancy. But as I said, you've got the issue that occupation has to be given up too, which means everyone that lives there has to have left, or else the tenancy is still considered to be continuing and her liability for rent could be continuing, which is a serious issue. One thing to know is that benefits in some circumstances can be received for two homes at the same time in the context of domestic violence, and that can be useful where a survivor needs to flee immediately but can't actually end the tenancy straight away without taking further steps. So in terms of trying to stay in the property, if that's what a survivor wants to do, if she's the sole tenant, so if she's the only tenant at the property, then she can, in law, simply exclude the perpetrator from the property. There are some practical issues with this, so she'll need probably to get her landlord's consent to change the locks at the property, and again, that's something that she can be supported with. And she may also need some kind of protective order against the perpetrator, because obviously he needs to be prevented from coming back to the property and trying to gain entry, and that's something that a family lawyer can assist with. And it should also be noted that if he's got matrimonial home rights, then you need to get a court order in order to lawfully prevent him from going into the property, whether that be something that the police help with or a family lawyer. If the perpetrator is a tenant, then the situation is quite a bit more difficult, because whether he is the sole tenant or the joint tenant, he's got a right to carry on living there unless the court makes an order saying that he can't, which means that in that situation, the survivor is going to need help from a family lawyer, most likely, and possibly the police, to help her get an order to exclude him from the property, because without that, she's not lawfully allowed to prevent him from coming back in. The guide has set out a number of sort of different protective orders that women can get, and I know that a lot of you would be familiar with these already from the work that you do, but quite a lot of different things can be achieved. So the perpetrator can be excluded from the property. He can be stopped from obviously visiting the property or contacting the survivor and possibly children. And he can be prevented from giving notice. That's really important because of what I was saying earlier in terms of if there's joint tenants, either one of them has the right in law to end a tenancy on their own. They don't need the consent of the other tenants. So that's something that potentially a perpetrator could use as a form of abuse. And they can be prevented from doing that by an order of the court. It can also give a survivor a right to occupy if she doesn't have one. So if she's not married, not a civil partner, and she's not a named tenant, then she can still get an order from the court allowing her to occupy the property. This is all part, by the way, of occupation orders, which are quite a broad category of order addressing the issue of accommodation. In the longer term, you can actually work towards having a tenancy transferred if you're not a tenant, but that does take some time, and it's probably of limited practical effect with private tenancies just because of the fact that the terms are usually quite short. It tends to be more relevant in the context of social tenancies where they're obviously potentially lifetime tenancies. But all of that requires a family lawyer. So I'm going to quickly talk to you about the availability of legal aid for when you're signposting survivors to lawyers. As you're probably all aware, legal aid is available in family, and that in the context of where there's allegations of domestic violence. So if your client is financially eligible for legal aid, then she can get help from a solicitor, and they can kind of do everything all together, because it might be that various different orders are needed, it might be that non-mol's needed, you know, and they can deal with the issue of occupation orders as well. And it can be helpful for you perhaps to help identify whether there are going to be occupation order issues, so that when the survivor is approaching a family lawyer, that can be raised at an early stage, because the applications can be made together. If there is also legal aid for housing, if a survivor has been served with notice by a landlord, and she's facing eviction, then legal aid is available for that. Unfortunately, legal aid is not available in housing law for general advice on options, for instance, how to remove a tenant or to negotiate with a landlord over a surrender. That's where we're hoping this guide is going to come in, really help, come in handy and help you to sort of fill that gap in a way, and to identify the basic rights so that you can actually provide some advice and support to survivors. And on that note, I'm going to hand back to Saranya so that Clementine can talk to you a little bit about how to use the guidance effectively.
Great, thank you, Angharad. That was really insightful, and there's a lot of information there that was provided, and I think for a lot of people it's very, very helpful to understand the different contexts, the different statuses, and how it impacts the survivor as well. So thank you for that. And a lot of that information is also within the guidance, because Angharad really did support us to create this, so thank you for that. And then finally, just before we have questions, I'm just going to pass on to Clementine, who's just going to talk about kind of how to use the guidance, and then we'll have a little bit of time for questions if anyone has any. So over to you, Clementine.
Thanks, Saranya. So yeah, I'll just show you where the guidance is and how you can use it. But before I go into it, I want to just say that I can't take any credit for this guidance. It's the work of my colleague DJ Cartwright, who used to be PRS lead before me at Standing Together, and she's developed the guidance and worked with Angharad to make sure it's all very useful for DA practitioners. So all credit to her, and we hope that this guidance will be useful for anyone working with survivors. So the guidance can be accessed on the DAHA website. So I've put the link here, and we will be sending the link to the guidance to all attendees after the webinar with the slides and the recording. So you should have everything there. Let me just, yeah. So how do you use the guidance? Who is it for? First of all, it's for anyone working with a victim of survivors of domestic abuse who lives in the PRS. So ITBAs, domestic abuse support workers, potentially refuge workers. So yeah, and it's a tool that is published on our website now. You can share it as much as you want with colleagues. And as Angharad said, it's really to provide you with some basic information of the rights of survivors who live in the PRS. There are some specific focus on their specific needs. So if a survivor wants to terminate the tenancy early, or who has a joint tenancy with the perpetrator, so there's specific chapters on this, and it's got a lot of very useful practice considerations. I will say that it's not legal advice. So if you do require to take action in terms of getting orders, etc., as Angharad said, you'll need to speak to a family law solicitor or housing solicitor. You can also check on the shelter website that has a lot more detailed housing advice. But this is kind of the basics of what is useful for you to consider when you support a survivor in the PRS. So the next slide is the contents of the guidance. As you can see, there's a lot of chapters. And so the aim is not for you as a domestic abuse practitioner to learn everything by heart and know everything that's in the guidance. It's more like a manual that you can refer to and know where to find information if you come against a specific situation. So if you have a tenant who might not know where the agreement is, you can check here in agreements and licenses, what that means if you have a lodger's license or tenancy agreement. If you're supporting someone trying to access the deposits after leaving a property, you can check that chapter. And I'll just want to draw your attention to one of the last chapters about helpful guidance questions. It's got a lot of kind of practice considerations to start with a client who is renting privately, because they might not know what is important to tell you. So it's got all the questions and Harad mentioned. So do you have a tenancy agreement? Do you have the list of the tenants who are named on this agreement? Do you know who is named for the deposit scheme, for example? So you can refer, like that can be a starting point in this chapter to start a conversation about the housing situation for your clients. And I'm just going to give a bit more information about the sanctuary scheme and flexible funding. So that's the interventions that I mentioned at the beginning that are part of the whole housing approach framework and that are relevant for survivors living in private renting. So the first one, sanctuary schemes. Some people call it target hardening or Bobby Van scheme. Basically, it's to install security measures to a property when the survivor wants to stay in that property. And it should be available across the country. Sometimes it's coordinated by the local authority housing team, sometimes by the police, sometimes by domestic abuse services. So you kind of need to check locally who is coordinating that scheme if you want to make a referral. And landlords need to give the consent, but it is free. So if you discuss with the survivor and they want to remain at home but want the locks changed or security measures in their windows and things like that, you might want to check with them if they're okay for you to speak to the landlords to agree to install those measures to help them remain kind of safer in their home. And you can kind of be the intermediate to speak to the landlord, to the private landlord on behalf of the tenants. And so there's more information on the guidance about this specific intervention. There's also flexible funding. It's a pot of money that some local authorities have. Sometimes it's coordinated by a domestic abuse service again. So it's best to inquire locally if it's available or not. And it's just to help survivors sustain or maintain their housing situation. And we know that a lot of survivors living in the PRS can kind of struggle financially because of the high cost of private renting. So that can be very helpful to help with a deposit or furniture or things like that. So again, it's very good to inquire locally if that's available. Finally, the next steps for our project is to share this guidance as wide as possible. We're going to pilot some training for domestic abuse services to help them implement this guidance, discuss like some case studies and what to do. So if you want to have training for your team on the PRS in general, contact me. My email is going to be in the next slide, and we can arrange training courses and see what's most useful for the sector. I'm also gathering experiences of survivors living in the PRS, in particular, diverse experiences of survivors from Black and minoritized communities, and in general, across the country, across the sector. And all of that will be used to influence kind of national policy change. There's the renters reform bill coming up, and we think that's a good opportunity to try to influence policy to support the needs of survivors of domestic abuse who are renting privately. So if you want to be involved in those discussions, please just contact me and we can discuss. So that's my email address, and that will be circulated afterwards. I'll just leave it there for now, and yeah, we can go into the Q&A.
Great, thank you for that, Clementine. So we've got about 10 minutes for questions. So I wanted to ask if anyone's got any questions. You can raise hand and also put the questions in the Q&A. So at the bottom of your screens, there should be a Q&A button. You can ask any questions to any of the speakers that we've had. So has anyone got any questions at all? Just a quick one. So can you provide the website address for this guide again, please? So yeah, can put that in there. And then we've just got a question from Erin. So what are the key reforms that you think are needed in the RB for survivors? RRB for survivors. So I think this is one for Harad.
You've slightly got me on the hoof there. I might pass over to Clementine.
Yeah, I'm happy to chip in. I mean, I think it's things that we are considering at the moment. I started the role recently, but we're starting to gather experiences of survivors in the PRS. And we know that nationally, government wants to introduce more regulation of the PRS. So it's just a good opportunity to start thinking about what are the needs for survivors. So, for example, protecting the rights of tenants is incredibly important. And there's been talk already of suspending the Section 21 eviction. So tenants can't be evicted for no reason. So when Forus mentioned survivors who complained about disrepair to the private landlords and then they got threatened with eviction, hopefully this will kind of no longer be possible. But we also think that there should be more protection in terms of the survivor's right to stay in a tenancy if they are experiencing domestic abuse and their partner want to threaten to terminate the tenancy, because that could terminate the tenancy for both of them. So there's things that could be put in place that we know is being discussed for the social housing sector. So for example, transfers of joint tenancy to sole tenancies is discussed in the social housing sector. It might be that we could start discussions in the private sector as well in cases of domestic abuse. But Erin, by all means, I think we can continue this discussion together. You're on mute, Saranya.
You'd think I'd learned by now, but clearly not. I was just going to say thank you for that, Clementine. There's also just a comment as well, just about wanting to know more about future training and how to get involved as well.
Yeah, I mean, so you can contact me for future training. So that will be part of the PRS project. We want to provide more useful training for domestic abuse services who are supporting people in the PRS. So we'll use this guidance to kind of have a bit more detailed training where we can kind of discuss case studies and where to find more information, how to actually take actions and advise survivors. I'll put my email address in the chat.
Great, thank you. Has anyone else got any other questions? Because if not, I have a question for Franky and for Forus as well. So just for anyone from your experience, essentially, from supporting survivors, what would be your advice to any new IDVAs in post as the first thing to do to support a client who have a private tenancy?
I think one major advice is avoid giving people unrealistic expectation. Very, very important. And again, it would be good if there's any issues for the professional to liaise directly as well with the consent of your client to the landlord. That way it's easier to resolve things if there's any issues. Yeah, thank you.
Yeah, I think for me, it's going to be around like supporting and empowering the women that we work with, particularly the minoritized women who have, additional barriers. So working collaboratively with other professionals, getting in touch with housing solicitors, barristers, or housing, shelter housing advice centers, getting the right advice and guiding the service users and also supporting them, because it's important to maintain their expectations, but I believe it's also important as professionals to inform them of their legal rights and support them in challenging, unreasonable kind of actions and interventions by the private landlords.
Great, thank you for that. That's really helpful. We've just got a question from Miranda from Richmond and Wandsworth. Hi Miranda, hope you're well. We've found issues with residents fleeing who are PRS and not claiming housing benefit or universal credit when they try to go into a refuge. The cost is really high and often not financially viable for PRS, considering they're still liable for the rent of their PRS property. Is there any additional financial support available to PRS not on receipt of housing benefit and universal credit? These survivors are falling between the cracks of support.
Yeah, it's a really difficult issue. If they're not eligible for housing benefit or universal credit, unfortunately, there really is not much in terms of benefits provision to help you with the afford paying for two properties at the same time. I mean, even a discretionary housing payment, you're not going to be able to apply for if they don't have underlying eligibility for housing benefit and universal credit. So yeah, it's a big issue.
Could it be in that situation, Ankara, to try to negotiate with the landlord to terminate the tenancy early if they don't want to go back to that property?
Yeah, I think in reality, that's probably all you're going to be able to do. And something to bear in mind is that even though you may be legally liable for the rent over the entire course of the tenancy, practically speaking, in order for the landlord to enforce that, they're going to have to bring a legal claim against you to sue you for the rent, which actually really, in practical terms, is often just not worth it for them, because, you know, at the end of the day, it's somebody that's not got a lot of money. Usually in these situations, there's usually financial pressure, and if they're going to get, you know, an order, they may never be able to enforce it anyway. So a lot of the time, you know, an effective negotiation to surrender the tenancy is what you need to do, and essentially explain the situation that you're not going to be able to afford the rent and therefore you want to give it up. But obviously that doesn't help in a situation where that's a property you would want to return to. I think there's another question in the chat rather than the Q&A function, but I appreciate it's 1 minute too.
Oh, yes, I'll quickly with 1 minute. So just a question from George. Do you have advice for advocating on a client's behalf to a landlord, please? So essentially, George's got a client who was on a joint tenancy with perpetrator. The landlord gave a Section 21 notice to claim possession after she called the police to report the abuse. The landlord said they didn't want to pick sides, so ended the joint tenancy. My client would like to be granted a sole tenancy to stay. There is an occupation order in place to exclude the perp.
I'll try and do this quickly. So yeah, this is the problem with Section 21, and essentially what I mean, advocating at this point doesn't sound like it's going to really get anywhere, because obviously the landlord's made their mind up about what they want to do. What I would say is that Section 21s have a lot of requirements in order to be valid, and actually landlords get it wrong a lot. So and once the notice has been served, there's eligibility for legal aid. So that person, if they're financially eligible for legal aid, could go and get some advice as to whether there's a defence to that Section 21 claim. And if there is, then they can defend those proceedings. There's already an occupation order in place. Eventually you could get a transfer of tenancy, but whether that's worth doing or not depends on, you know, as how long that tenancy is going to last for, really, because if it's going to be terminated quite shortly anyway, then it may not be worth going down that road, unfortunately.
Great, thank you, Karen, for answering that so quickly as well. It's 12:01 now, so we've come to the end of the event. Just want to say a massive thank you for everyone that attended, and also a massive thank you to all our speakers for taking the time to attend this event and kind of share your experiences as well. This event is being recorded, so there will be this will be available on our website alongside the guidance as well. And if you've got any other questions or would like to get in touch with Clementine or generally about the whole housing approach, please do email Clementine, who's put her email address in the chat as well. So thank you so much, everyone. Thank you for attending, and especially to the speakers as well.
Thank you. I'll end the webinar.